Excellent. Well, welcome. Thank you all for joining us this afternoon. As you know, we have dedicated this week to a variety of events to celebrate Justice Scalia and his legacy. And we are delighted that all of you have chosen to spend your afternoon lunch hour with us to talk about that legacy and to receive interesting comments and perspectives from 4 current judges who all had the honor of clerking for Justice Scalia at one point in time. I am just here to help guide the discussion, so I'm not going to say too much as a matter of introduction. I'm going to get out of the way after I give an intro of each of our judges, and then we will have a series of questions which we'll go through the group to discuss, and then reserve some time at the end. So please do get ready to ask your questions about the experiences of the jurists in front of us and the wisdom that they might impart upon you as you begin your careers. So with that, I'm delighted to have these 4 jurists with us today, starting with Judge Daniel Bress on the far end. Judge Bress is a circuit judge on the U.S. Court of Appeals for the Ninth Circuit and has been seated there since 2019. He graduated magna cum laude from Harvard College and received his JD degree from the University of Virginia School of Law, where he served as editor-in-chief of the Virginia Law Review. He clerked for the Honorable J. Harvey Wilkinson III of the U.S. Court of Appeals for the Fourth Circuit, and then the Honorable Antonin Scalia of the Supreme Court of the United States from 2006 to 2007. Judge Bress was then a lawyer in private practice, first at Munger, Tolles & Olson, and later at Kirkland & Ellis, where he was a litigation partner. Next to Judge Bress is Judge Joan Larsen, who is a judge on the U.S. Court of Appeals for the Sixth Circuit and has been seated there since 2017. Judge Larsen received her BA with highest honors from the University of Northern Iowa, and she graduated first in her class from Northwestern University Law School. She was also articles editor of the Northwestern University Law Review there, and before her appointment to the federal bench, Judge Larsen served 2 terms as a justice of the Michigan Supreme Court. Before becoming a judge, she was also a faculty member at the University of Michigan Law School. She clerked for the Honorable David Santel of the U.S. Court of Appeals for the D.C. Circuit before clerking for Justice Scalia in 1995 to 1997.
1990. OT 94.
Sorry, OT 94.
You're making me younger than I am, so I have to own up to it.
Apologies for that. Following her clerkship, she joined Sidley and Austin, later served as Deputy Assistant Attorney General of the United States Department of Justice in the Office of Legal Counsel. Next, we have Judge Roy McLeese III, who was appointed to the District of Columbia Court of Appeals in 2012 by President Obama. Judge McLeese received his BA cum laude in 1981 from Harvard College and his JD cum laude in 1985 from the New York University School of Law, where he was editor-in-chief of the Law Review there. He was a law clerk to then Judge Antonin Scalia on the U.S. Court of Appeals for the D.C. Circuit, and he then clerked for Justice Scalia in 1986 to 1987. Judge McLeese joined the U.S. Attorney's Office for the District of Columbia, ultimately becoming Deputy Chief of the Appellate Division, and later twice serving as the Chief of the Appellate Division. He also served as an assistant to the Solicitor General of the United States and as acting Deputy Solicitor General of the United States. Judge Patrick Schiltz is a U.S. District Court judge for the District of Minnesota and has been there since 2006. He served as Chief Judge since 2022. He is a graduate of the College of St. Scholastica and Harvard Law School. He was a law clerk also for Judge Scalia on the U.S. Court of Appeals for the D.C. Circuit and then joined him when he moved to the Supreme Court. He was in private practice in Minnesota and a law professor at the University of Notre Dame Law School and University of St. Thomas School of Law, where he also was an associate dean there. And obviously, each of these judges have a much more extensive bio than what I've just given, but in order to get to the wisdom of the group, we will leave it there, and please do look into their backgrounds even more after the program is over. So what I'd like to do is just start. We have really almost a decade apart between this side and then along the way, so maybe we start from the earliest era. And I just thought I'd invite a few opening comments from each of you about how you became clerks and sort of how you entered into the orbit of Justice Scalia.
I was a law student at Harvard Law School, and I was on the Law Review in the fall of our second year. People started saying it's time to apply for clerkships, and I kind of didn't know what a clerkship. I grew up in Duluth, Minnesota. There were no lawyers in my family. There were no college graduates in my family except for one. So the one thing they told me I needed was a reference, a professor to be a reference. So I went over to a professor named Clark Bice, who was an administrative law professor. I'd had him first year, and I said to him, you know, I need a reference. You were my favorite professor, so will you be my reference? Made sense to me. He didn't know who I was. We were 150 people in my class. So he hemmed and hawed, and you know, I don't really know you. All I could tell you is that you got a good grade and blah blah blah. And I didn't realize that he was kind of interviewing me while he was telling me he wouldn't serve as my reference. And then at the end, he said, "Well, you know what? Let me think about it." And then I walked over to, it's called Gannett House. It's where the Law Review had its offices. After I talked to Professor Bice, and I went in the door, and the receptionist said, "Professor Bice is on the phone." And so I picked up the phone, and he said, "Judge Scalia will see you tomorrow if you can get down to DC." And I couldn't get down to DC tomorrow, but I got down a couple days later, and I interviewed with him. And in the meantime, I faxed. You can look up on the internet what that is. I faxed my resumes to a couple other judges, and I got to talk to Judge Ginsburg as well while I was down there. But I interviewed first with Judge Scalia. We had a great interview. It was like an hour and a half. We talked hardly any about law. It was mostly about families and faith and, you know, football and whatever. And at the end of the interview, he said to me, "I really like you. I'd really like you to clerk for me. I think we'd be a great match. But I'm afraid if I offer you a clerkship, you're going to think I'm desperate and you won't take it. So should I offer you a clerkship or not?" So we talked about it. And we decided that if I was going to clerk for him, he would have to offer me the clerkship. And he did. And that's how I ended up with Justice Scalia. And then both Roy, if you followed the math, Roy and I were co-clerks both at the DC Circuit and at the Supreme Court. Both of us had clerkships lined up with Justice O'Connor at the Supreme Court. But during it was like my last week or two, sort of similar to you, Justice Scalia got nominated to the Supreme Court. And he asked Roy and me to go with him to the Supreme Court. Justice O'Connor let us out of our commitments. It probably took her 30 seconds to replace us. Roy can speak for himself. I just thought the chance to be at the Supreme Court with Justice his first year would be a really special thing, and it was. It was really interesting. And Roy and I were remarking, three of us have been at this AEI commemoration of Scalia's death, and I was struck by how much different, like, clerkerati wasn't a thing when we were there. That was invented after us, and just how much different things were. We were there at the beginning when it was all being constructed. So that's how we ended up. Roy ended up at the Supreme Court. Is he asked us to come with him to the DC Circuit.
That's impressive. I remember so much less about it. I remember I applied. I couldn't tell you anybody else I applied to at all. I do remember the interview, and it was really fun. I had written a law review article. I think part of the reason Justice Scalia was interested is I'd written a law review article about the relationship between the DC Circuit and the Supreme Court. And so it was pretty much in his, obviously, right in his area of interest. And so we talked a lot about that because he was quite interested in that. And he definitely did not either offer me a clerkship during the interview or ask me whether I would like him to do so. So there was some time that passed thereafter, I'll call that. And then in terms of the Supreme Court, yeah, it was, I mean, we'll talk more about what it's like to work for Justice Scalia. It's an incredible experience. It was for me, and the idea of getting to do it another year and also do it his first year on the term on the Supreme Court was invaluable. The other thing I'll say is, you may have heard the term counter clerk, which was not really a term that was around at the time that Pat and I were clerking. But Justice Scalia had a tradition at times of not hiring only law clerks who he thought had the same substance as he had. So I was a counter clerk in substance, so that wasn't the label. So, and that was part of my thinking about applying. My background was that my mother was a very conservative Republican, my father was a Democrat, and they spent the whole, every dinner was the two of them arguing about politics. So I had, if you've ever heard the term Overton window, kind of a range of view about where reasonable disagreement is. I had a pretty broad Overton window, and I applied. I do recall some of my peers applied kind of in ideological ways, and I did not really. I was not, that was not the way I was looking at it. So we'll talk more about that, but that's my story, to the extent I can remember.
Yeah, okay, so I will help back. So I clerked OT 94. And back at those times, the justices, I don't know why on earth they did this, but I got my clerkship during my Supreme Court clerkship during my 3rd year of law school. So I had my DC Circuit clerkship I got that clerkship during my 2nd year of law school. And then it was during finals week of my 3rd year of law school that Justice Scalia called and asked if I would come and interview. And I had to beg, one of my professors didn't want to let me reschedule my exam. I'm like, are you kidding me? I really have to go. I think the law school would like this if I did this.
Take the F, just take the F. Go on.
Well, I will say that that was American legal history, and Justice Scalia hired me before he saw that grade. So that was good. Yeah, so I interviewed for the job during my 3rd year of law school, and I had 2 wonderful professors who had been Scalia clerks. So that is definitely what helped me get this job. I never would have gotten that job without Steve Calabrese and Gary Larsen, who really, I'm sure they went to bat for me. But one thing that nobody did was tell me what the interview would be like. And I had interviewed on, for my Court of Appeals clerkship, I had interviewed with several judges on the DC Circuit, and on the 4th Circuit, I interviewed with Judge Wilkinson and Judge Niemeyer up in Baltimore. I had done a week of, several days of interviewing up and down this corridor. So I kind of thought I understood what a clerkship interview was like you'd meet with the judge and it'd be pretty friendly, and then maybe there'd be a substantive question or 2, and then meet with the law clerks and it'd be more substantive, but not super substantive, and I just didn't know. So I arrived in Washington the day before my Scalia interview, and I went up to see Judge Santel, who I hadn't clerked for yet, but who had hired me to clerk for him the next year. And I thought, well, I'm in DC, I'll go see the judge I'm gonna clerk for. And I met with the judge for a while, and his current law clerks were there. And there were some clerks from other chambers. One was from the Williams chambers, who was down in Santel chambers just hanging out. And that guy was Mark Phillip, who had also been hired to be a Scalia clerk the year before me. And he said, "Are you ready?" And I said, I think so. And he's like, you're ready for the clerk grilling part of the interview. And I said, what's that? What nobody had told me is that the clerk interview portion of the Scalia interview is like a 2-hour grilling on any esoteric subject that these brilliant young people can come up with. And I literally had no idea. This is the day before my interview. And Mark Phillip, God bless him, went back to Judge Williams' chambers, and he said, "I'm gonna make you a packet." And he made me a stack. He just photocopied, because it was old days. He photocopied things out of books. And he made me a stack about this big. And he delivered it to my hotel room. And I stayed up all night and I read the whole packet. And then I went to my interview the next day. And sometimes you gotta cram for a test, and I guess it worked. So I owe my clerkship to Mark Phillip, Steve Calabrese, and Gary Larsen.
Okay, well, thanks for having me. I'm from California, so I had to find my coat to show up here again. And I just want to say to the students, thank you. It was such a great turnout, and you're at such a fine law school, and congratulations to all of you on the hard work and success that have brought you here, and I know there'll be much more of both in store in the years to come. So I clerked for Justice Scalia in 2006. You know, I never in a million years thought I would do any of the things that have come my way in my career, and there's been so many things that happened by accident or by weird quirks, or somehow they worked out, and none of it made sense at the time, and none of it makes sense now, but it happened. So when I was in law school, I didn't come to law school with a lot of preformed ideas about law, but one thing that I did start to learn in law school was the views of Justice Scalia, and they really resonated with me in ways that were surprising. I found a lot of his ideas very powerful. Never in a million years did I think I would actually work for him. When I was at 2L, I went to UVA, and during the winter break, I stayed at the law school to work on a paper. My now wife, she came down from New York, and we were working. She was a law student too. We were working in the law school library, and no one was in there, but a man and a woman walked in. This is back when the justices didn't have the huge security details that they have now. My wife said, "I think that's Justice Scalia." This was, we had the internet, so we could kind of know what he looked like. I said, I cannot imagine that he's here. And it turned out he had, I think, a child who was at UVA, and he just stopped by the law school just to check it out. So she said, "No, you should go say hi to him." I said, I can't do that. And she said, "No, this could be the one time in your life that you could meet him." So I said, okay. I got up the courage, and I walked up to him, and all I could think to say was, "Are you Justice Scalia?" And he looked at me and said, "Somebody has to be." So that was my first interaction with this man. And then, in law school, much along the same lines, it turned out that I took classes with professors and others who knew him. That was not why I took the classes. I had no idea they knew him. I did not know that they knew him. And I was clerking for Judge Wilkinson, and I got a phone call asking me to interview. But the interview, there was not a lot of lead time. Like Joan, I was a very sophisticated law student, and I don't know that anybody was at the time. I feel like everyone knows too much now. The whole thing has gotten corporate, but at the time it wasn't. The way I got my clerkship with Judge Wilkinson was I went to a professor and said, "I've heard about these, clerkships opportunities. Do you have any ideas for that?" And she suggested I clerk for Judge Wilkinson, and that worked out. So with Justice Scalia, I think I got the call like on a Thursday. The interview was on a Monday, and Judge Wilkinson said, "Well, you should call this former clerk of his who would be able to help you with this and give you some pointers." So I called him. It was Jeff Wall, who was the Solicitor General, actually turned out to marry Judge Wilkinson's daughter. So he became a very close friend, but I'd never talked to this man in my life. He had clerked for Justice Thomas. So I called Jeff, said, "Yeah, Judge Wilkinson said to call you. I have this interview." He said, "Yeah, well, when's the interview?" I said, "It's Monday, it's in 3 days." Just silence on the other end. And I said, "Yeah, you there?" He said, "It can't be done. It cannot be done." That was that experience.
It can be done in 24 hours.
So yeah, you don't have to do well in the interview, you just have to pass. And so I think I got a pee. And I had a great conversation with the justice. And then when I started with him, I realized the whole thing might have been even more of an accident than I realized, because there was a lawyer who had clerked for the justice named Rick Bress, who you all I'm sure know. Well, I didn't know of this person. He and I have both exhaustively determined we're not related. We actually tried to figure this out. We're not related in any way. But then when I started with the justice, he called me down and he said, "How's Rick doing?" I looked at him and said, I don't know who you're referring to. And just the look on his face was, I've made a terrible mistake.
Well, thank you so much for those initial reflections. And I realize there are many students in the room I've not yet met. I'm Donald Koch, and I'm a professor here in the law school and also the executive director of the Law and Economics Center. I never had the privilege of interviewing with Justice Scalia, but I want to share one quick story, because the next thing I want to ask you each is to reflect on the justice as a man, a boss, and a mentor. But especially with what Judge Bress just said, I was fresh off my circuit court clerkship. It was the fall I was entering a law firm, but I got this opportunity to go to the inaugural week-long program that Justice Scalia was doing with Professor Baker on statutory interpretation in Colorado Springs. And I got on the plane in DC, and I passed by Justice Scalia as I went to my seat way in the back, and I realized, yes, the justice is on the plane. Then when we get to Colorado Springs, I find myself on the escalator behind him. And I had a very similar moment where like, am I gonna go introduce myself or not? I'm gonna be spending a week learning from him. He was giving lectures the entire week on statutory interpretation. So I mustered up the courage, went down the escalator and said, something to the effect of, Justice Scalia, I'm very excited to be spending the week at this program. I look forward to seeing you there and everything. We get to the bottom of the escalator and there's, the baggage claim was right there. He's carrying a bag. And this also was, there's no security around or anything at this point in time. He's carrying a bag and I said, well, I have a bag I need to get from the baggage claim. And so I'll see you at the Broadmoor. And he's like, no, I'll wait. And I'm like, oh, well, it's okay. He's like, no, we'll take my car. And then we proceeded to go on this drive from the airport to the hotel. And all he really wanted to talk about was faith and family and just sort of get to know me. And it really was a testament to how, what a wonderful man, just connected. He wanted to learn about my family. He wanted to tell me about his. And so that was a very special moment in a young lawyer's career. And I can't imagine how it would be to be around him constantly, to have that kind of connection. So can you tell us a little bit about what it was like being in chambers? What really did that experience feel like to you?
Well, there was good things and bad things about being around him constantly. Roy, when we got there, his first year, office space at the Supreme Court was by seniority. So he had the worst chambers. And the worst chambers were worse because, among other things, there was only room for 2 clerks there. So 2 clerks had to go upstairs, and we had the worst of the upstairs. So we had literally like a big windowless closet, Roy and I were in. But the deal we made was after 6 months, we got to move down, and the other clerks would have to move up. Well, 6 months came, and we said, we're good. We'll stay up here. Because when he would have some idea or something, he didn't even know how to find her. I mean, I think literally once.
He was up there once. At least.
One time he was up there and he seemed surprised by the squalor.
And the dinosaur.
And the dinosaur, yeah, we had a great big blow up dinosaur for reasons that I've lost over time. But let me just, I'll do one element and then each of us can do different things so we just don't repeat ourselves. One of the great things about clerking for Justice Scalia is the amount of personal interaction about cases. And Justice Scalia, and I don't know if this was the same for you folks or not, we never wrote bench memos for him. He didn't believe in bench memos. He's told me, but probably Roy, look, I read all the briefs. I don't need a 26-year-old to send me a memo about the briefs I just read. It just gives me more to read. I don't need that. So he would talk to us before arguments. What do you think? And then at the Supreme Court, I don't remember this at the DC Circuit. I think it was just because we were just assigned 1 clerk. But at the Supreme Court, we'd sit in his chambers before he'd go to conference to vote. And we would argue through the cases. And it was just, that was my favorite part of the clerkship. And it was really interesting. And he did change. Roy was the counter clerk. He was the liberal in chambers before we didn't have that concept of counter clerk. I was I would call myself kind of non-ideological. And then we had 2 clerks one was kind of a traditional conservative, one was more of a libertarian conservative. So we really talked about stuff and we changed his mind. I mean, he would start and change his mind and that was just fun. And I guess actually the most fun was when he'd come back from conference and he'd call us down to the room and he'd just tell us how everybody voted, how the cases were coming out. So that's what he did very little emailing at the time. When we started, they had just kind of invented email. And at the Supreme Court, they wouldn't let it connect to the outside world at all. You could only email each other. And though your email handle was the first 6 letters of your first name. So if you were going to email him, he was Anton, I think, or Antony. Roy's wife, who was working for Justice Brennan, her name's Virginia. So take the first 6 letters there, and that was, you'd literally email Virgin. So there was little emailing, there was, it was in contrast to the lack of discussion among the justices, but it was just a very lively, very oral place. We didn't send memos back and forth, and that was my favorite part of clerking for him.
And I agree with all that. To add other nuances, Pat said there are good things and bad things. One thing about it, I wrote an essay, if people are interested somewhere, I think it's a Harvard Journal of Law and Public Policy after Justice Scalia passed away, about what it was like for clerking for him. This is a short essay, so if you want to read more, there's more there. But I mean, it was not for the faint of heart, in the sense that he loved to argue and debate, and that was great if you were self-confident. But I mean, he took no prisoners at all. So for sure, he said to me, and probably twice as often said to Pat, "That's the stupidest thing I ever heard."
He told me I had pudding for brains
Yeah.
once.
And
Not
so-
a compliment.
And so it was really fun, and he did not want you to stand on ceremony. If you responded by saying, well, I guess you don't listen to what you say, I mean, that's what he wanted, was like just absolute war of ideas. Was not really too worried about trying to be, worried about how people felt about it all. He was just like, these are my ideas, here are yours, I want to hear yours, I want to destroy them if I don't agree with them. And it was, I mean, exhilarating and fun and incredible education as long as you were self-confident. The other thing I'll say just about clerking for him, I mean, it was an extremely formative part of my development as a lawyer for sure. I learned a ton of things. He's an incredible writer. I learned a ton about how to write clearly and concisely. But the thing that struck me the 2 years that we were clerking for him, and this is early on, so was he had this, an intense desire to understand the law and get it exactly right. And it didn't matter how obscure the case was. I mean, I worked on some case on the DC Circuit about how to value railroad rolling stock for purposes of ICC ad valorem taxes. And he was as focused and intense and passionate about getting that right as he was about, I worked also with him on a case about the constitutionality of a big major statute and its appointment provisions. And that was really inspiring, that he just wanted to get it right, every detail, every aspect of it. And he was, it was really an intense commitment to try to sort that out. It was, I thought, very inspirational.
Yeah, I don't know how much I have to add. I will say my story is very similar. My co-clerks, I think you must have invented the idea of switching chambers after 6 months,
Or not.
and the drawing the long straw was to get to be downstairs with him, because that you would first get to know him, right? So there was the downstairs, his chambers, and then, where the assistants sat, and then the law clerk chambers, and everybody wanted to be downstairs first. And so we literally drew lots for this, and my co-clerk and I drew the short straw. And so we went upstairs, and we thought that we had invented the idea of, well, gosh, possession is 9/10 of the law. And so now that we all know him, we're not giving up the upstairs space, because otherwise he would come in all the time. So we also did the adverse possession thing. I will also say that I clerked for him relatively early. So he was appointed to the bench in 86. I clerked for him in 94. And when I clerked for him, he had only had one other woman clerk for him before me. And then there were a bunch after. When you mentioned the squalor, and when I got into that upstairs chambers, I think I found your coffee cup. It was like growing this, then I thought, how long has this been here? It was some kind of biological experiment up there. Anyway, Justice Scalia was, everything they said is true. He liked to spar. He really wanted to get it right, to the point where he would have you, when you wrote an opinion, he would have you, we had books in those days. This is how we did legal research, in books. And he would have you wheel this library cart with all the citations, every book that you had cited, every opinion or law review article, whatever it was, had to be on this library cart in the order in which they appeared in the opinion. And you brought the cart in, and you sat next to him on this big leather couch, and he had the opinion, and you would hand him the source. And he also was a speed reader. So he would read not just, oh, here's the sentence that is cited here, but the whole case. And you sat there and just Great. And he taught me that, first of all, every case needs to stand for the proposition for which you say it stands. And also, even if part of the case that you're citing stands for that proposition, but ultimately it reaches a different result, find me something else, was his response. And so he was very careful. He really, really cared about getting it right. And that just was very inspiring.
Let me add a couple of things to these great comments. You know, there's a mystique that he knew all the answers to everything instinctively, which was not true in my experience. He had some very firm ideas about certain areas, but there were things he hadn't seen before, even by the time I got there. There were certain areas that he hadn't discovered, or at least there were new questions that would come up. And he never assumed he knew the answer to those things. What I observed was that he was extremely diligent in kind of flipping the case over and over and over. He was willing to be challenged, and he challenged us, but it was never in service of a result. It was in the process of trying to get to the best result. And I saw him change his mind, which always impressed me to think, you know, this is a person who knows more about law than anybody on this planet, and yet here he is wrestling with these same questions that I'm wrestling with. What was inspiring when I worked with him was just how seriously he took this from top to bottom, the rigorousness of the approach. And once you learn that as a young person, you just can't go back because you saw what it took to be that good. I mean, to have the confidence and to be able to know the area and then to write it in the way that he did. Again, people have this assumption that he would just sit at his computer and whip these things out. Not true. It took hours and days and revisions and sitting on the couch with the cites, and even then when he was checking the cites, he would make adjustments. You know, he would make adjustments, he would read it out loud. I saw him read out loud the same paragraph multiple times with different intonations to see how it will work, checking the hinges in the from paragraph to paragraph. And when you saw him doing that, you realize, like, okay, if you want to be really good at this, obviously you have to have some natural gifts, which of course he did, but that was only part of it. A huge part of it was just the sweat equity he put into the casework and the writing in particular. And that was my big takeaway from that year with him, was that if you want to be that good, you just have to work that hard.
Judge Bress, maybe we can start on your end and let you keep going for a minute. How has any of that affected how you run your own chambers, how you manage your own clerks, or how you develop relationships with your clerks? How much of the experience in chambers led to how you manage your own?
You know, very much so. I mean, I think inevitably you're influenced by your mentors and by your parents and by all the people in your life that kind of form you. Certainly in terms of the clerkship, you know, the clerkship was fun. I mean, going to work was fun. It was hard, but it was fun. And I felt like every day I was learning and I got to interact with him. And so I try to have the same mentality. I want this to be fun. I want people to learn. I want to see them, talk to them. And a lot of times people come in, I said, let's talk about this case. And they come in with like a laptop or an iPad or a brief. It's like, just put everything to the side. Like, let's just talk about the case, because that's what he liked to do. I like to have people encouraged to tell me what they think. You know, it doesn't do me any good to have somebody come in and say, you know, when I make a point, say, that's an excellent point. You know, that doesn't really lead to a good outcome if someone else is going to have a different view of the case. So please, I'm encouraging you to push back. And at some point, the discussion is over and I'll make the call and we'll execute on it. But it was that kind of spirit of discourse that the justice really, that's what he had in mind for what was going to reach the best results. And that's very much how I operate.
Yeah, I would say much the same, to sort of echo something that Judge McLeese said, which was about treating every case as being very important. I mean, obviously every case at the Supreme Court is very important, but not every case that is at the Supreme Court is very interesting. And what I tell my clerks all the time is, so when the year I was clerking, we had a case about the Plant Variety Protection Act. And it was complicated and it mattered to people in Iowa, where I'm from, and Minnesota, and not really too many other places. And And the justices didn't know anything about farming either, so I did have to do a little explaining to Justice Ginsburg. She's like, I hear you're from Iowa. So in any event, Justice Scalia was assigned to write this case about the Plant Variety Protection Act, and he had no interest in this case whatsoever. And he worked so hard figuring out that statutory scheme because he wanted to get it right, even though we had, I mean, the year I clerked, we had United States versus Lopez, we had Rosenberger versus the Rector, which was a huge First Amendment case. We had Adirond, which was one of the early affirmative action cases. I mean, we had just United States term limits. We had just a ton of like high profile stuff. And Justice Scalia worked very hard on all those cases and also on the Plant Variety Protection Act. And so one thing I always tell my law clerks is, we're gonna work on a lot of cases that are like interesting, pushing the boundaries of the First Amendment or whatever it might be. And we are also gonna do a lot of criminal appeals, and we are gonna do a lot of employment discrimination cases, and we are gonna do a lot of Social Security appeals and immigration cases. And there is no case more important to those litigants than that case, even if it's not that interesting to you. And so I need you to treat the First Amendment case like you're treating the employment discrimination case. And I think that's something we really learned from the justice.
With one exception, I do my work in chambers almost exactly with a little higher tech assistance, the way the justice did. So I don't use bench memos. I anything of I do some of my own drafting. The justice didn't do much of his own drafting. He just destroyed ours. But I do some of my own. But with my law clerk's drafts, I tend to destroy them, and I don't put anything out under my name unless I personally site checked it. I don't use a cart, but I do it electronically. I do a lot conversationally with my law clerks. So all of that I try to replicate. The one thing I don't try to replicate is that's the stupidest thing I've ever heard. I do try to make it a kind of a kinder, gentler experience. The mode of discourse.
One of the stupidest things I've ever heard.
Yeah, usually I say I haven't heard anything that stupid since I was co-clerk. That's the way I try to put it. But I would say, I don't think I could have had a better clerkship experience, and so to the extent I can, with that one caveat, I really try to replicate it. I think it led to high quality work being done. It's a lot of work to do it that way. It's a lot of work for the clerks. It's a lot of work for the judge to do it that way. But I think it leads to high quality work, and it also leads to a great experience for the law clerks in terms of learning about writing and learning about precision and detail. I have a little. I give my law clerks a talk with them when they start about writing, and I have a little slogan for what I'm looking for, which is nice, precise, and concise. Two of those things I got from Justice Scalia. The nice part is my own little slight departure.
So I'm the one trial judge on the panel here, and my job as a trial judge is much, much different than Justice Scalia's job was. I have spoken an entire hour to law schools about the difference, and Justice Scalia would have been a horrible trial judge. He knew he would have been a horrible trial judge. We asked him, have you ever thought about going and trying a case? He said, heavens, I'd be terrible at that. But there's still some things that translate. I don't do bench memos. I'm the only judge in Minnesota, federal judge in Minnesota that doesn't do bench memos. I talk to my clerks before argument. We go hear the argument. I have, it's what lawyers call a hot bench. I don't let them give speeches because all they're telling me is what's in the briefs. I've read the briefs. So I start with a question and we just discuss the case. Then I discuss the case with the next lawyer, and then I'm done, and I come back, I talk to my clerk, and I tell them to, what I want in the draft. So it's a very, that I get from Justice Scalia. My counter clerks, I'm a Republican appointee. I've probably had 25 clerks or so, and maybe 3 have been conservative. Maybe 22 have been liberal. I don't hire for ideology. I just get many more out there. There are many more liberal law students, so I get many more liberal clerks. But my career clerk, who's been with me from day one, is liberal wouldn't capture it. She thinks Bernie Sanders is a squish. She gets mad at him for his cowardice. So she's really, really, really left-wing in her politics. She's a fantastic clerk. So just as Roy was very different in his personal politics from the justice, the things that they had in common is a belief that law and politics are not the same thing. And what we do in judges' chambers is law, it's not politics. And she's been a superb clerk. But it really helps me. So one of the differences between my job and Justice Scalia's job is I make a ton of decisions that I don't have any guidance from the law other than just or right or good cause. And, think of sentencing. I sentence 3 or 4 people weekly. When I'm sitting down and giving a sentence to somebody, and I could sentence them probably, a typical, serious case, I could give them 10 years, I could give them 25 years, and not be reversed either way. That decision, I don't have there's no judicial philosophy that's going to guide you through some statute. I often tell people ask me at law schools, like, what's your judicial philosophy? And I say, well, that's for appellate judges. I don't have a judicial. My philosophy is I learn the facts, learn the law, and do the best I can to apply it. So that has been very helpful. Because so much what I do is kind of human intelligence, to have someone who grew up differently, who formed opinions at different times and in different circumstances, it's just really interesting to talk through, is this a defendant who's really, really sorry and has a good chance of turning his life around? Or is this guy just just a con man? And the more diverse views you can get on that, the better. And then I spent a lot of time on my orders. When I became a district judge, my fellow district judges said to me, don't spend a lot of time in your orders. They're not precedential. They don't bind anybody except the parties. Parties just want to know what you think. They don't care about your reasoning. And so don't spend a lot of time on your orders. Just tell them briefly why you're, and I haven't taken that advice. I spend a lot of time on my orders, but I don't have time like an appellate judge to spend times on. I know you folks do per curiams and administrative orders, but I can't really write on everything. The volume's too high. So what I have to do is I rule from the bench a lot. There are some cases where I can just do a 2 or 3 page order that just says, there's a split on this issue among the circuits. 8th Circuit hasn't decided it. I've read the cases. I really think Judge Larsen's opinion for the 6th Circuit and such is uncitable. So therefore,
Darn.
no, it's right. I can't really say anything she hasn't already said, and therefore I agree. Sometimes you can do that. And so I have to kind of save my spots for when either I have to write, like if I'm granting a summary judgment motion, you can't really do that from the bench, or if there's an interesting issue, like we in Minnesota, you may have heard where we've been busy in Minnesota the last few weeks. We've had a lot of issues that have never arisen before because no administration has ever taken the positions that this administration is taking. I don't say that to say they're right or they're wrong. I say that to say we've got a lot of brand new issues that there aren't any precedents on. And so, I devote my time to that. And then just very quickly, the last thing is something that you've heard from everybody, which is you never take a case off. There's never a case that's unimportant. There's never a case that I don't try really hard. And that includes pro se cases, these handwritten cases. And I have the lunch with the clerk when they start, the brand new clerks. And I always, tell them how important that I tell them the only fireable offense other than ethics problems, the only fireable offense is not doing your best to get everything right. I say it's my job to build the building, but it's your job to give me bricks, and I have to know each of those bricks is solid. And I tell them it's like a heart surgeon. You can't. If I go in for heart surgery, open heart surgery, that's my one and only open heart surgery, and I don't want my cardiac surgeon to be having a case of the Mondays. I'm really low energy today. No, you're not. You're doing my heart surgery. You can't have an off day. And I won't say it's especially true in the district court, but the district court, it's much more personal. It's much more face to face. It's the people who are involved in the case are usually in the courtroom, and for trials, they're in there for days and days with me, and the attorneys are there. And it's people who live, when Dan decides a case, it might be somebody from Hawaii or from Washington, or when you decide a case, it could be from Kentucky or Ohio. the cases I decide, the people are my neighbors. It's my neighbors that I'm ruling on their cases generally. So despite our jobs being very different, all of those I think are things that I've incorporated for Justice Scalia into what I do.
Thank you. So I think anyone can start to answer this next question. So I'll kind of open it up to who has an idea. I want to move to a couple questions designed to help the audience better understand Justice Scalia's judicial philosophy through your eyes. And so are there any particular cases that you worked on during your time clerking for Justice Scalia that you think are emblematic of his judicial philosophy, or the experience in developing them helps maybe a teaching moment on his methods of interpretation, something that you recall that of a particular case?
So I can do a simple one. When we clerked, we had a Ferris Doctrine case. I don't know if you know what the Ferris Doctrine is, but it's a doctrine that says that a service member, someone in the Navy or Army, whatever, who's injured in the course of their service can't sue the federal government. There's a law called the Federal Tort Claims Act that allows people to sue the government under certain circumstances. It totally fits to service members. In most cases, they should totally be able to bring those lawsuits. But years ago, in a case called Ferris, the Supreme Court basically said, we're going to bar those cases because they'd be a bad idea. That was the reason. It would be a bad idea. And you folks, it's partially it's a testament to the impact that Justice Scalia has had on the law, that you probably don't even read cases anymore where it's a statutory interpretation case and the judges are saying, oh, the text, yeah, it says that. But really what this law is about is justice. And this result would be more just, even though it's not in the statute. But those cases were quite common. When I was clerking, you'd read these in the late 70s, early 80s cases. They were really common. This was a Supreme Court case. So Justice Scalia, this case would have extended Ferris a little further than had been extended. And Justice Scalia thought Ferris was a terrible idea. The Supreme Court held that the claim was barred by Ferris 5-4. Justice Scalia wrote the dissent for him, Brennan, Marshall, and Stevens. Blackmun, who I used to like to say, always voted with never voted with the conservatives unless they were wrong. Then he would come over and join them. He did that, true to form. He joined and provided the fifth vote. But that was what Scalia agreed it was a bad idea to let somebody who was in the Army, who was injured in the Army, to sue. But it was clearly allowed by the text of the statute. And that it's just like a really simple example of he had his principles. It was not results, it was methodology.
So I thinking about the cases we had my year, I guess I'll talk about one in which he didn't write. And I think it also reflects something about Justice Scalia, maybe how he contrasts with Justice Thomas, for example. So my year, the court decided United States versus Lopez, which you probably, hopefully still read. You can't carry a gun within 1,000 feet of a school zone because that is outside of Congress's power to regulate interstate commerce. I will say when I went to law school, we were just taught that, maybe there's some end of the commerce power, but we've never seen it. When I took Barbary, they told us, if it's multiple choice, right? So if you see one that says this is beyond Congress's power to regulate, you just cross that one off and now you're down to 3 because that's obviously not the right answer. So, the Fifth Circuit had decided that this Gun-Free School Zones Act was outside of Congress's power. And, that was like a bomb going off. Like it hadn't happened in 60 years that somebody had ruled that way. And the Supreme Court granted cert. And I will tell you, all the clerks, at the beginning of the term were just betting. We just all thought they granted it to reverse because, they had not found anything to be outside of Congress's power in 60 years. So Justice Rehnquist, he was the Chief Justice, and he kept the case for himself. And he wrote, an opinion that sort of took the facts of a lot of the cases and made a doctrine out of them, even though maybe they didn't. Maybe that's not what the rationale of each of the cases was, but you can find a through line in all the cases, and he wrote an opinion without overruling any case that said that this was beyond Congress's power. Justice Thomas wrote separately, you may remember, and Justice Thomas has this very pure, I think, exposition of the limits of Congress's power under the Commerce Power. And it's this nice, sort of originalist opinion. And Justice Scalia doesn't join it. And I'm not revealing any chamber's confidences about, this is just my thoughts about why I think he didn't join it. I'm not telling you what he told me about why he didn't join it. Because he didn't tell me anything about why he didn't join it. But my thought about that is, Justice Thomas, this was the first time anybody had done this, right? Nothing was beyond Congress's power to regulate in 60 years. And Justice Thomas writes this very nice originalist thing, but this lovely originalist opinion, if he had 5 votes for it, would literally have crumbled everything. It would have taken the whole House down. And I think Justice Scalia, I think that reflects a little bit of Justice Scalia's pragmatism. He may have agreed with Justice Thomas about what the pure Constitution meant, but he was more pragmatic than that. And I think he was more gradual. He believed in stare decisis, even though Justice Rehnquist's opinion, it honors all the old precedent. It doesn't overrule any of the old precedent. If you were going to go with Justice Thomas, you would have had to bulldoze the old precedent. And so I just think Justice Scalia was a little more of a prudentialist than Justice Thomas. He believed more in stare decisis and going slowly, at least in the early part of his tenure. So that's just an example.
I'll try to do 2, and I think they were I think these might have been the cases you worked on, but there were 2 criminal cases we had that were confrontation clause, Bruton kind of cases. And so this is Justice Scalia's first year. Yeah, it was what we exactly. And his first year on the Supreme Court, he's understood to be a conservative justice. I think there was a sense or a prediction that as a conservative justice, you are pro-government in criminal cases. And I think some of the conservative justices were pretty reliably pro-government criminal cases. And the outcome in those cases was mixed, but it was, what they reflected was not, that was not the kind of conservatism that he was driven by. And this is sort of consistent with the result idea. I don't think he had a view of it's really important that criminal law be, allow the government to have expansive powers. He wasn't coming at it from that perspective. He would come at each issue and he would try to make the law make sense. And if there was a doctrine that favored the government, but it didn't make sense to Justice Scalia, he had no trouble. That came up later in things like Crawford and the Confrontation Clause, where he was, his body of work is very favorable to criminal defendants. So it was his judicial philosophy was really not outcome driven in case specific policy ways. It was his commitments were extremely strong, but they were more abstract, and they were about some were about judicial method, but some just also I think he said this is his phrase that he didn't make up, about the law working itself pure. And he thought that part of the function of the Supreme Court was that there would be these areas where the cases, they didn't fit that well and you couldn't make sense of them. And the job was to try to continue over time to bring clarity and internal logic to the law so that it would work better. And those were his commitments that seemed to me much more important to him than the outcome of a particular case.
It's a really good observation, because what the justice had a very deep insights into was the judicial role, and specifically the judicial role in the system of government that was given to us through our Constitution. It was a uniquely American vision of what the judicial role should be. And it was also an understanding that the judges would err quite seriously if they stepped on things that were the responsibility of others in our system, including people, right? Including people. And that it was up to American people through their elected representatives to choose certain things, perhaps to make mistakes. It was not the role of judges to come in and assert their own will where it wasn't otherwise justified under law. And one that gives a good example of this, I think the criminal cases are a really good example. Another one is in punitive damages. And we had a case my term about this. There was great controversy, and still is, about the size of punitive damage awards, that they're just too high. They're bankrupting companies. They're giving people windfalls. We should have lower. There should be caps on punitive damages. And some states had enacted these caps, but some hadn't. And so in the states where they hadn't, there began to be challenges by companies saying, this amount of punitive damage is just too high. It violates due process to be giving somebody $10 million of punitive damages when their compensatory damages were really quite minor in comparison. And the Supreme Court, really led by Justice Kennedy, developed a doctrine under the Due Process Clause that did put limits on this, that said, well, really the outer range should be 10 to 1, and that, in the normal case, it should be more like 2 to 1 or 4 to 1. In egregious cases, maybe 10 to 1, but that would be extreme. And, I can only imagine what the justice actually thought of punitive damage awards. I don't really know, but I can believe that he might have thought, like many people do, that they're problematic. But he was never with Justice Kennedy in these cases, even though it was a windfall to plaintiffs' lawyers and plaintiffs. And I think that kind of really exemplifies his judicial philosophy, which was that that's a decision that should be made democratically, not by judges. And it's just one example among many in his entire body of work that speaks to that principle.
So I want to get to the audience questions in just a moment. So I have one question I'll reserve for the very end, and one question before we get to the students. And that is, and you each have touched on this a little bit, but sort of a lightning round on just the claim I think can be made that the world would be a very different place if Justice Scalia wasn't ever on the court. And so can you sum up what is Justice Scalia's legacy for the court, for society, and for the path of the law?
Lightning round. Textualism, which is just the importance of text, which nobody even questions anymore, and that was him.
I'll say two things. One is favorable, which is that. I think that's the easy answer. I will say one thing, which is back on my topic of tone and the like, because I do think that his writing has been highly influential, his mode of writing, in good ways, trying to be clearer and simpler. All of that is great. He was very combative in tone. I'm not really a fan of that kind of tone in judicial writing. Different people have different views about that, just speaking for myself. I do think that the tone of judicial opinions, the kind of hard-hitting tone, is another legacy which you could debate whether, my own view is I think it would be good if everybody dialed down their tone.
There's a case you might read in admin law called City of Overton Park. It's a famous admin law case, but when nobody reads, there's this footnote in City of Overton Park that says, the legislative history being ambiguous, we now turn to the text of the statute. Right, I can always get a laugh out of a room of lawyers. And the reason you laugh is because Justice Scalia made that footnote absurd.
Certainly text is a big one. I guess I would broaden it a little bit and say, the intense rigor on what's authoritative in law, and the intense focus on methodology, and the insistence that judicial methodology be harnessed to legally valid sources is, I think, his lasting legacy.
Questions from the audience?
I've got with you.
Yes, and if you can stand and just so you can project so the whole room can hear.
You shared incredible insights on how Justice Scalia has shaped your legal thinking, your lives as attorneys, successful attorneys, and of course, successful judges. But is there anything that you can share about how he shaped your life in terms of just being a better human being?
Roy, I probably knew him the longest because I probably interviewed before you, so by like a month. For me, it was, I'm a practicing Catholic, a devout Catholic. My faith is very important to me. And he and we never got together without at some point somehow connecting things to faith or to religion. Robbie George, there was a talk at the AEI event yesterday, but one of the things I said that Robbie George from Princeton gave one of the talks, and he talked about how, I think it was him, maybe it was somebody else, but anyway, the point was, there's a perception in the wider society that religion is, smart people aren't religious. They're mutually, so this is one of Roy's beliefs, they're mutually exclusive categories.
No, I know smart people are religious, you're just not one of them.
But he just, there's nobody smarter, there's nobody more successful, and he was very, very, just the way we talk about things, his faith was very important to him. So for me, it was always kind of an inspiration that was the major impact I think he had on my personal life.
I'll say something that's in a way related, which is he was a very combative guy, as I said, and he loved to argue and all of that. But he had a lot of tolerance for people who had very different views from him in fundamental ways. And so he didn't demonize people. He was very close friends with Harry Edwards, a judge in the DC Circuit, completely different views. Very close friends with Justice Ginsburg, completely different views. And so although he took no prisoners when he was debating them and they were performing their functions and the like, personally, he had close friends and could be very warm with and get along well with and exchange views with people whose perspectives on critical things, not just trivial things, but the most fundamental things were diametrically opposed to his. And I think that's a good thing to learn as a young lawyer, as you practice law, and I think nowadays it's particularly salient as things. There's a lot of heated dispute in our country for sure, and I think that helped me a lot. Internalize early on that you can disagree about important things and still have a lot of respect for people, nonetheless, and treat them well and be warm and friendly to them.
And before we move on to the others, that is the inspiration for Scalia Law's colloquy, the Scalia-Ginsburg colloquy that you see that we hold occasionally each semester. So please look at that in that spirit.
Yeah, I would say much the same. I mean, Justice Scalia famously said on 60 Minutes when he was asked how he could be such good friends with Justice Ginsburg, he said, I attack people. I attack ideas, not people. Oh boy, get that, sorry. The other way around. I attack ideas, not people. And I think that is just a lesson that we could all really draw from these days. He also said there are a lot of really good people who have really bad ideas. And to be able to separate the two. Also on the faith front, it just goes back to the combativeness. I have never been so terrified or had as much fun debating the virtues of the Reformation with Justice Scalia.
He wasn't a fan.
He wasn't a fan, but I mean, come on, selling indulgences. I mean, anyway, we had a good time.
I have much the same. I mean, certainly on the faith side, he had a lot of Jewish clerks. I'm Jewish, and my year that I clerked for him, we had 3 Jewish clerks, 1 Muslim clerk. And so I always thought that was fascinating, that the justice was very receptive and welcoming of people of different faiths. And actually the Jewish Scalia clerk squad is a very tight-knit group within an already tight-knit group. And the justice had a real joy for life, and that I think was impossible to, it rubbed off on everyone in some way. He liked living, that's part of what made him such an enjoyable human being. One piece of advice he would often give was to go home, and I did go home eventually, finally got back home, but he would tell people to do that, and I always, took some comfort in that you could leave Washington and life would be okay, but there were lots of things in just the way he interacted with people, especially ones he disagreed with. I think the Ginsburg-Scalia relationship was a real one. It was a real genuine friendship, and it kind of taught me that it is nice to have friends who think differently. You don't have to talk about all your disagreements all the time. You can just be friends, and that was kind of what I observed of the two of them.
I want to say one other thing, just to emphasize one thing. He had an incredible zeal and joy for life, and even really serious law can be really fun. And so have fun while you're doing it. Enjoy it. I got that, and I try to replicate that in chambers too. It's really important, and you're trying to get something really important right. It's important if you're writing presidential opinions for other people. If you're deciding individual cases, those are critical to the people. So you can't take it lightly, but you can have fun doing it, and you can enjoy it. I don't think I'm not sure I fully internalized it ever, but I definitely try to internalize that, because I think it's a good lesson for a young lawyer to take away. This doesn't have to be like angsty. It can be fun.
Other questions from the audience?
Wow, really?
Yes, Thomas, stand please.
Yeah, first of all, thank you all for being here. Great to hear your stories. I'm curious, I picked up on something earlier that Justice Scalia didn't think that he would be a good district or trial court judge. I'm curious to know where that was going.
So the reasons I can remember are, for one thing, is the decisions I make as a district judge, especially when I'm in trial, I maybe have a second to make him, maybe two. He wouldn't like that. He wouldn't like that. Another part of being a district judge is it's just so standardless and squishy, right? Like the statute that governs my sentencing is 18 U.S.C. section 3553. And it tells me that I have to impose a just sentence. That's the guidance I have. It gives me certain factors I can look at, which basically cover everything. You can, well, you prosecuted, so it's, all the characters and history of the defendant. And in fact, if there's anything as a judge you say you're not considering, that's a sure way to get reversed. He would have just hated, so, you take a guilty plea from somebody, and their attorney's arguing for the 10-year minimum, and the government wants 240 months. And you have to decide it based on the history and characteristics of the defendant. This just isn't what he liked doing. And he would have considered this social work, or he just wouldn't have liked that. And he was very deferential as an appellate judge to those kind of decisions by a district judge, because he recognized, I think correctly, that appellate judges may disagree, but he recognized correctly that he's in a far worse position than the district judges are to be making those decisions. So and I don't do what, I sit down and do a hard statutory construction issue, once every 2 or 3 months, maybe. I spend more time on contracts. I do interpret those, but I just spend look at what I've been doing the last few weeks in Minnesota. He would hate every moment of my life right now. It just isn't what he liked doing. I don't know if he ever talked to any of you about it, but
I also would be a terrible trial court judge, so.
I also wouldn't want to.
You'd be horrible, I
He
know you
was a
will.
law rule guy. What he liked was, what's the logical structure of this? Give me some time to think about it and figure out complex legal structures and logical rules and reasons. That's what he liked. And that's not a district, that's a part of a district court job. That's why it's so hard. You have that job too, but then you have all the other stuff that is not where his interest lay.
You manage people, you manage, you have to make decisions. You really have to have really strong people sense. And it's not that he didn't, but he was kind of a performer, and he loved people and he loved to perform. But make no mistake, in any room he was in, he was the bride at every wedding. He was the corpse at every funeral. And if he wasn't, he'd get a little itchy. So and a district judge, so much of it, you kind of have to swallow that. You kind of have to, I don't know, you have to influence people to make decisions that they think are theirs when they might not necessarily be. It's just a whole different job, and he wouldn't have liked it, and he recognized that. He used to like to always mention, you may have heard this, but Richard Posner is the great appellate. Posner tried 3 or 4 cases, I think, and they were utter disasters. I think he got reversed twice by his own circuit. And I talked to an attorney who was involved in one of those, who was saying how Posner would he'd rewrite the jury instructions. One thing you do as a district judge is you kind of give the standard jury instructions because the circuit approved them. So if they reverse you for giving them, they're reversing themselves. And Posner, of course, thought, oh no, I could do much better. He got twice reversed because he did that. And so no, he wouldn't have liked it.
Yeah, this is a little off topic, but for those of you, you're here in a major metropolitan area. When you're in law school, you read appellate cases all the time. You read what we do. Go sit in a district court and watch what they do. It's really amazing. I mean, I sat in, well, I was just waiting for a friend of mine who's a district judge in Chicago. We were gonna go have lunch and he was running behind, so I sat in his courtroom. And just the range of things they deal with and how different it is from what you actually see in law school. Just go sit in district court and watch it, you'll learn a lot.
Or intern or extern for a district
Yeah.
court judge. Even if you think you don't want to do litigation, you don't know what litigation in federal court is until you see it.
Yep.
You're not going to get that in law school. You're not going to get it from books. You're not going to get it from mock trials.
Last question.
Thank you all so much for coming. Judge,
I like that you all dress, all the questioners dress just up here.
Judge Larsen, you mentioned a time where Justice Scalia chose not to join an opinion. And so I was wondering if you all, especially appellate judges, could speak to how your experiences with Justice Scalia inform when you write separately or choose not to write separately.
I won't join an opinion that I don't think is right. Now, I've looked back at some that I've joined and now I think they aren't right, so don't hold me, but at the time I thought I was right. But I will work really hard, because we have 3 judge panels, not 9. So I'll work really hard behind the scenes to try and get the things that I don't like taken out of the opinion. When you're on a 9-member court, that's a little harder, I think. So he would just not join footnote 4 or subpart 1A. And sometimes I end up having to do that, but yeah, I am able, I think, fairly effectively to work with my colleagues to get something that we can all join. It's a little different, I think, than Justice Scalia's style on that.
Yeah, it's a harder choice on the Supreme Court because you need to get to 5, and if everybody is doing their own thing and they can't work out some kind of compromises,
Yeah.
sometimes it's so fragmented it's useless. He was not afraid to write separately, and I'm also not afraid to write separately. And like Judge Larsen, I'm not going to join anything if I don't agree with it. So I work hard to try to get that out, and I work hard to compromise. But some judges will have more of a compromising view where it's I agree with the bottom line and I'll go along with parts, something that I don't agree with to make sure there's a majority on something. I draw the line there, as Justice Scalia absolutely would have. And I think, and some judges are afraid to write separately or, feel as though they should be reluctant to do it. I don't feel reluctant to do it if I feel as though I can't join something or I need to explain something. I don't myself write concurrences just explaining my views on related topics. I try to make it, anything, if I'm writing separately, it's load bearing, not, just popping off because I have a microphone. But I think the main thing I was influenced by is Justice Scalia, for sure. He was not going to join something he didn't agree with. He would try hard to get people to change it and all that, but he drew that line, and I certainly